Good afternoon and happy Friday to you all. This is WLVT's Ask the Experts. I'm Kelly Boyd, and joining me here in the hub today is attorney Ronald Morton, Morton Law Firm. Welcome back.
Hi, Kelly. Thanks for having me.
Thanks for being here today. So today our topic is probate law. We have questions from our Ask the Experts page on WLVT.com, all related to probate law. So if you have questions while we're live on Facebook, you can ask attorney Ronald Morton while we're live on Facebook as well. So first of all, what is probate?
So probate is the legal process that we go through to transfer assets from deceased people to living people. Mm-hmm. You know, while you're alive, you control the things that you own. You can assign title to them, you can manage them and such. When you die, there's then a question mark of, well, who owns title to this now? Probate answers that question. And so it does so, it exists for two reasons. One, we want to make sure that if you owe people money, that they have an opportunity to get paid. And so probate really is the forum, the exclusive forum for those people to step forward and say, hey, Kelly owed me money, and so before you give her money away to her kids, you should pay us.
All
and
right.
so that's one function of probate. The second function of probate is to make sure that the heirs have an opportunity to step forward and say, I'm entitled to money here as well, so that someone's not left out, so that someone isn't declared to be an heir, or someone's not telling the court about something. That's really why we have probate. And it's a rather lengthy and archaic process designed to accomplish those two goals.
Okay.
The third goal, if you will, for estates that have wills is to make sure that the will is valid, so that it's a forum also for if people want to challenge the validity of the will, they can do so in the probate. A court actually overlooks that will to say this meets the requirements, and so this will determine now who owns these assets, or this doesn't meet the requirements, in which case then the estate is what we call an intestate estate, meaning an estate where someone died without a will. So that's really the three things that we do with probate. But the short answer is
it's put in place for fairness. I'm sorry, I didn't mean to cut you off
No,
there. I was kind of asking a question, so it's kind of put in place for fairness to people to get the debts to get paid, what's owed, and then the heirs to get there.
And so that we can have a valid record of title that we can rely on. So whenever someone buys a piece of property that your name is on and you're deceased, you can't rise up from the grave to sign that deed.
Right.
So the court basically says, okay, well, now that Kelly is deceased, this is now the new owner. So when someone wants to then buy that property, they know who they're dealing with. And more importantly, they're not lying awake at night worried about, well, is there somebody else out there? Is there some creditor? Is there some other heir? So we can rely on a chain of title.
Okay.
And probably even as important as me relying on that chain of title is our banks can rely on that title so that they can feel comfortable loaning money on a car, loaning money on real estate, so that they aren't worried about, does this person actually have valid title or not? Probate really resolves and answers those questions. Okay,
and you've written a book about it, so this probably tells all about probate in this book?
More than you'd want to know.
The probate book.
It's the probate book. That's right. Yeah, it's written for consumers.
Okay.
And so it's certainly, and by the way, we make that available for listeners or viewers on this. I think the price of this normally is about $20 or so, but you can get one free if you'll text the word probate to 601-600-2662.
All right.
And we can give you a free copy of that book. So we'd be happy to do that if that's something you're interested in.
Okay.
You could also call our office at 601-ELDER-LAW. And so either of those.
We'll bring that number on the screen. There you go.
Perfect.
Okay.
Yeah. So either way, you can get a free copy of that book.
So they can call 601-ELDER-LAW to get a free copy of this book. That is worth $20. And they can text the other number. We'll put that number in the comments if you missed it, or you can go back and watch it later.
Yeah, 601-600-2662. Just text the word probate, and then we'll ask you how to send that to you, and we'll get that information from you and send it to you.
All right. Melinda Dees is asking us about the weather. Melinda, the only way I can tell you about the weather is if I get my phone and go to our WLBT weather app, free weather app, by the way. Let us know where you're watching from. Maybe I'll check that out while he's answering our questions here for you. All right. First question from the Ask the Experts page is, when do I have to go through probate?
Well, obviously, when someone dies, but it won't be the deceased person going through probate. It's going to be their heirs generally going through probate. So the probate process really is anytime there's a question as to who owns title. And so certainly if the title is held just in the name of the deceased person, that's when we go through the probate process. If the asset's not owned by that deceased person, then it's not the part of their estate. It doesn't go through the probate process. Sometimes that's because the property is jointly owned. There's like joint tenants with rights of survivorship. And so that in that case, then the survivor is the owner. There's no reason to probate that. Other times the property has pay on death designations, so a beneficiary named. And then again, that property also would not have to go through the probate process because it passes by declaration of title or by declaration of law, depending on the circumstance.
Okay.
And so we don't have to go through probate. But other than that, if the deceased person owns assets at the time of their death, in order to get clean title to those assets, make sure that the creditors are taken care of and they don't have some claim, make sure that all the heirs are identified and that it passes to the right people, make sure that the document, if there is a will, is valid, that probate really handles that. That's what probate's for.
Okay, great. How long does probate typically take?
So that can vary. The typical time probate takes is about 9 months. The absolute shortest it could be is about 4 months and a week. The reason for that is that there are lots of what I call speed bumps designed in that probate process. Because again, remember why we have probate is to protect unknown heirs and to protect unknown creditors, or any creditors for that matter, but to identify unknown ones and to protect all creditors. And so we want to have a slow process before assets get distributed so that those groups have an opportunity to find out that this person is deceased, if they have an opportunity and a forum to assert their claim. The court can then determine this is a valid claim or not, and then we distribute assets. And so part of those delays, if you will, are designed intentionally like a 90-day period of time that you have to advertise for claims. In other words, before anything can be done, as far as distribution of assets, there has to be a publication in the county where the decedent resided or in the county where the probate is pending that basically tells the world this person is deceased. If you have a claim, this is the place to do it. And you've got to wait 90 days after the date of first publication before you can do anything. So that's 3 months right there that we're kind of sitting around not doing anything. On top of that, in order to open the estate, you've got to file some papers, and so that takes a little bit of time. Then you have to, again, file some other papers to close the estate. You have to give notice to certain people. Sometimes you have to publish a notice and have a determination of heirs. All of those things delay the process. So generally speaking, 9 months, sometimes as long as a year. On rare occasion, if the stars align up right with the lawyer's schedule and the court's schedule, and we're able to get in and out very quickly and such, maybe as short as 4 months, but most frequently between 9 months to a year, if it's a fairly simple probate. Now, if there's contests, and those contests may be because creditors claim they are owed money, and others heirs say, no, you're not a valid claim. That's going to be a contest. Sometimes the contest is heirs claim property that they think they're owed while others say they're not.
So the heirs make contest claims.
Right. You can have sometimes we have a contest of you're an heir, no, you're not, or I'm an heir, no, you're not, type thing. Any of those things will delay that process even further. There'll be evidentiary hearings, there'll be discovery that takes place. You're really in the middle of a lawsuit as part of that probate process, and it will delay things dramatically. I've been party to a probate that have lasted over a decade. In fact, I've been in multiple ones that have lasted over a decade. That's the exception, not the rule, but it does happen.
Wow.
It's not terribly unusual to have one last, in excess of 2 to 3 years if there are disputes or if the estate is large and complex. Sometimes we have estates that are so complex and we have to deal with things like estate taxes and worry about clearance letters and things like that. That will also delay one. Most people in Mississippi don't have to deal with that. The estate tax exemption number now is so high that only the super wealthy really have to be concerned with it. But there are other things that will delay one. Usually it's fights. If everyone's getting along, if the lawyer is doing their job, if people will sign things in a proper way, 6 to 9 months is fairly typical.
That's with no disputes.
With no disputes, everyone getting along. But sometimes you have people that they don't really have a valid dispute, but they're not going to cooperate. And so they refuse to sign things. So then every time we do something, we have to give notice. We have to give 30 days notice in many occasions. Have to wait for that. Have to serve process on people and things. That will increase the cost and increase the time that it takes. So cooperation goes a long way in making that process slower.
The next questions are actually about cost, but I was going to take the ones on Facebook that just came in first. Dwayne Seeger says, I'm studying this currently in paralegal studies at Hines, and it's very interesting, all the steps that you have to go through.
Yep, it is, and it's a process that probably hasn't changed much in the last 300 years. The way that we do it now.
It must work.
Well, the way that's law changes very slowly, and so the way we do things now are pretty much very similar to the way we did them 200, 300 years ago. Abraham Lincoln would recognize the processes
really?
that we're going through, but not be foreign to him.
Wow. So. Okay. You may have some advice on Emily Hopkins' comment. She says, just put your things in your kid's name. That's simple if you don't want them to go through this stuff.
Well, and that will avoid the probate process, absolutely. So that is one way that some people will try to avoid probate. The thing you got to think through, though, is do you want your kids owning your things? Because once they own your things, it's not your things anymore, it's their things. Yeah. And they can do whatever they want to with it. They can spend it, they can give it away, they can lose it in a poker game, they can sell it. They may lose it not because they're bad people and would take it from you, but others may take it from them, like in a lawsuit. And so they get sued because they have late payments on their house, and they get a foreclosure with a deficiency judgment. Okay. Now then that lender can go after anything they own, which is the stuff that you used to own because you transferred it to them. There are also, for some assets, adverse tax consequences to doing that. So giving those assets away like that can actually cost your kids money because they lose some of the tax advantages that are built into the system if you inherit property that doesn't exist if you are given the property.
And in the episodes we've had with you before on elder law and Medicaid law, age may be a factor too about giving their stuff away if they may need nursing home care later, right?
Yeah, I mean, sometimes people will give stuff away in order to start that 5-year clock running for Medicaid purposes. Again, there are lots of bad things that can happen. We generally do not advise giving it away to the kids because of so many things outside of your control and sometimes outside of their control. The same would hold true with giving assets away for probate. Most of the time, there are other ways of handling it, again, depending on the asset. Certain assets, like financial assets, can have pay on death designations. So you can be the owner, but it says pay on death to my child. Okay. That asset would avoid probate, but you're in charge of it as long as you have a pulse. And so you're not giving it away, you're not making it subject to your child's divorce, not making it subject to your child's creditor. You're still in charge, but you avoid that probate process. Not all property you can do that with, but a lot of the property you can. And so many times we'll avoid probate doing that. Another common way that we will avoid probate, if probate avoidance is important to you, is to create a trust. And generally we call that a revocable living trust, a trust that is what we lawyers would call an inter vivos trust, a trust created during the lifetime of the individual, where that trust then is controlled by the former owner of the property. They will then take that property and transfer it into that trust so that the trust becomes the owner. The former owner then just becomes the manager and the beneficiary of the trust. So when that person dies, again, remember why we have probate, is to determine who owns this. There's no question about ownership. It was owned by the trust while you were alive. It remains owned by the trust at your death. We don't need a probate process for that. We have a successor trustee that takes over. They have instructions in the trust as to how we're going to divide that property out. And so we can handle that privately, quickly, efficiently, and inexpensively without involving some court that knows nothing about you, that you had nothing to do with choosing or anything else, and that many times costs a lot of delay and costs a lot of money. Again, following this archaic system, we can eliminate all that by having those assets owned by the trust during lifetime and just continue to be owned by the trust at death. And that takes away the uncertainty of, again, losing them to lawsuits and losing them to a child squander. You're not giving up control. You're simply having those assets owned by an entity that is immortal rather than someone that's going to lose a pulse at some point.
Okay. All right. Libby says, Libby. She says, my sister passed away a week after she was approved for Social Security disability. She has no husband or children. Can her siblings secure her benefits due before her death for her nieces and nephews, which are her designated beneficiaries?
So I do a lot of public benefit work in the area of Medicaid qualification. I do not do Social Security disability work. So my short answer to that is I don't know the answer to that.
Okay.
My thought is, and actually I have had some experience in that, is yes, that you can get, if the approval was done during lifetime, I do believe that there's a way to get that shortened part. The reason the experience I've had with that is that happened with my brother-in-law. He died. He had a pending claim, and then the claim was actually awarded after he passed, and so that those funds were awarded to his estate.
Okay.
So I believe that would be the case in your circumstance, Libby, unless there's something else that I'm not hearing. Obviously, on a show like this, we're not really rendering advice. We're giving information because we don't have the opportunity to ask all the right questions. But I would check with someone, if not the Social Security office, check with someone that handles Social Security disability work, and they can answer that question with greater certainty than I can.
Right, and good luck on all that.
Yeah.
All right. So the next questions I told you from the Ask Search page are about cost. I'm going to put them together because one says, how expensive is probate? And then the very next one is, why is probate so expensive? So how expensive is it?
So I guess everything's relative, right?
Right.
And so, the cost of probate in most cases, again, estate sizes vary dramatically. Everyone has an estate. The size of the estate, though, can be multiple millions of dollars. It can be very modest. Obviously, the fewer assets you have, the simpler the assets are, the less expensive that process would be. The more complicated things are, then the more costly it's going to be, simply because of the time involved in managing those assets during that probate period. So with that giant caveat, the typical Mississippi probate that we see, someone that dies owning a home, owning a couple of cars, has a checking account and savings account, that's a fairly typical estate, mom and pop type of estate. Those probates generally run, as long as we're not selling real estate during the probate, between $3,500 and $5,000 is a fairly typical fee for that. If we're selling real estate or some other property that requires a court order and court approval before we can do it, the cost of that is going to increase a little bit because there's some extra work we've got to do. We usually have to get an appraisal on it to show the world that we're treating fairly everyone, because there's a potential for creditors to be cheated, if you will, if we made a sweetheart deal to someone. So there's some steps there, and then we have to get court approval generally for those types of transactions, and so those additional steps will take additional time and cost additional money. So it's not unusual in those cases for the probate to cost somewhere between $7,000 to maybe as high as $10,000. Now, that being said, I've participated in probates where the attorney's fees were tens of thousands of dollars. I've participated in probates where the attorney's fees have exceeded $100,000. Those are complicated estates, though, with lots of moving parts, and that take lots of time. So that is not the typical estate at all. The typical estate where you've got, again, a couple of accounts, some real estate, a couple of cars, and such. Generally speaking, is going to take about 9 months, and it's going to cost somewhere between $3,500 and $5,000 in my experience.
And is it typically the responsibility of the heir or your consumer for this is the heir to an estate?
So statutorily, there's a kind of a hierarchy, if you will, of people that are preferred to be the ones to open the estate, or preferred to be the ones managing the estate. And so if you're married, a spouse obviously fits in there. If not, then the siblings, or children first actually, then siblings. And so there's a statutory order that goes in. Generally speaking, it is a relative of some sort. Usually people aren't clamoring about who should be it. It's usually a chore that someone has. If you have a will, then you actually get the privilege of naming who that person's going to be. So you name an executor, and that person then would have the first authority and obligation to step forward and probate that will and seek appointment by the court to fulfill their role.
Next question is about a will.
Oh, okay. Well,
should we go into that?
We can.
All right. They say, I have a will. Does that avoid probate?
So that's a very big misconception. I talk to a lot of people. One of their big goals is they want to avoid probate, and they say, but I'm not worried about it. I have a will. And they misunderstand that a will, while it will change the disposition of properties to who gets what from the statutory default of what we call our intestacy law, you can bypass that or change that with a will, but the will goes through probate, just like an intestate estate goes through probate. In fact, a will is not a will until it's been recognized as such by the probate court. So that's the first step in probate is this a valid will or not? That's the first question that is determined by the court. Once that's determined, the court also then appoints someone, usually the person named as the executor, to be in charge under the court's direction and supervision. And then that person then carries out the wishes of the deceased person, reporting back to the court when appropriate, reporting to other heirs and creditors when appropriate, notifying the proper people according to the statutes and then ultimately 6 months, 9 months, a year later, stepping forward to the court and saying, this is the stuff this person had, these are the people that are entitled to it, this is how I propose to distribute it. And then everyone can agree, some may disagree. If they disagree, we're going to have a hearing on it. If everybody agrees, the court will sign an order generally distributing that property. That's what probate is. But the very first step is this a valid will or not? Okay. Because wills can get kicked out. There are a lot of reasons that wills can be invalidated. They can be invalidated because they weren't signed properly. Sometimes people signed in the wrong order. We had one thrown out with last couple of months or so where the witness signature wasn't a valid signature on there. The parties had used some shortcuts there, so the will was actually invalidated as a result of that. Those are things that the probate court has exclusive jurisdiction to determine, and that's why we have probate. Sometimes wills are challenged because the person creating the will might not have had capacity or might be unduly influenced by someone else. Any of those things can result in
so
in
wills
that will
can be
being
commonly
invalidated.
challenged.
They can be. And
they're at first recognized as wishes, and then they see what's legal and go from there.
Well, and that's part of the reason that we give the invitations, if you will, to the heirs, to other people, to heirs or potential heirs, because some heirs may be getting something under the will, but it gives the opportunity for others to say, well, at least you have knowledge of this, and then they can go in and say, well, wait a minute, this isn't valid, and here's why it's not valid, because on the date that this person signed this, they had been declared a week earlier as being incapacitated by their physician, so they didn't have testamentary capacity. And so that's why we have these delays. If we didn't, then the court would say, yep, it's a valid will.
That's sad you guys actually uncover these types of things.
Yeah, it's... and we're seeing more and more of it. Part of that is because of the level of wealth that is in the baby boomers, and they're reaching the age that they're passing on now, passing on a significant amount of wealth to, their children generally. The children are not as close as they would have been 30 years ago. Most of them don't live near one another, or at least frequently don't. And so you have a lot of people that are absentee until suddenly the estate's being divided up, and now, oh wait, I get my equal fair share. And so we're seeing more and more disputes of that. We get calls every week with questions about the validity of a will and maybe seeking a challenge to that. So that's part of why we have probate, is to say, is this thing valid or not?
All right. Libby said, thank you for your response, by the way.
Oh, great.
Corey Elder wants to know, if it is $50,000 or less, do you have to get a lawyer and go through probate?
So that's a great question. What she's referring to is, in Mississippi, we have something called a small estate affidavit. So if you meet certain requirements, then you can use a small estate affidavit to transfer property, personal property, that's worth, as long as the totality of that personal property is less than $50,000. Now, there's some giant caveats to that, one of which is if you have real property, if you have real estate, then your estate's not comprised of only personal property. Personal property is things, it's stuff. Real property is real estate. And so if you own real estate, then you're not going to be able to validly sign a small estate affidavit because it violates the terms of that. In addition to that, if your estate is worth more than that $50,000 at the time of death, then again that affidavit can't be signed. The other time that the other thing about those affidavits is they're very specific as to who's entitled to sign those, and so it's spouse and children. When you go beyond that, then the affidavit doesn't work, and so sometimes we'll have a situation where someone dies and the heir is a grandchild, for instance, and it seems like we're not able, I think, to use a small estate affidavit in that circumstance. Certainly a brother or sister doesn't fit in that category, so it wouldn't avoid probate in that circumstance. So the answer, I would say, is sometimes, but it's not something you can necessarily rely on. Just say, oh, well, my estate's worth less than $50,000. We've had several times where we've attempted to use that only to find out, well, the estate's not worth $50,000, it's worth $52,000. And so we can't sign that affidavit and have to open up a full probate because...
Or $50,001.
$50,001 makes it not qualify. That's exactly right. So those things can and do happen. The other thing that can happen is people may not cooperate. So we've had a situation recently where we attempted to transfer some property that the person died. I think the what we were dealing with really was some vehicles that was needing to pass to the surviving spouse, and rather than have to open a probate, we were just going to handle it through a small estate affidavit. Well, there were some stepchildren involved, and one of the stepchildren refused to sign the affidavit, refused to cooperate. And so ultimately said, well, we can't force you to, but everyone has to sign on these affidavits in order for us to be able to make this transfer. Since we don't, since you're not willing to transfer, we are going to open an estate. We are going to probate that. The vehicle's still going to go to the wife because that's how the will is going to leave it. But we're going to change the will at next death, and we're going to reduce your share by the cost that it took for this entire probate because this is totally unnecessary. By the way, that child then saw the light and signed the affidavit.
Signed it. They changed their mind.
Yeah. But it still wound up costing some extra work because I had to deal with this squabbling child that was trying to make what point, I don't really know.
So whatever their portion of that vehicle might have been was probably going to cost them more paying their portion of probate, right?
Absolutely, yeah. It wasn't their portion; it was a full amount of probate we were charging.
Okay.
At the time that they inherited.
All right, Corey gives the thumbs up. Thanks, Corey. And so a lot of the information we're discussing is going to be in your book, right?
It is. It's in the probate book.
Book.
We talk in great detail about those things. And so again, if you want a copy, call us at 601-ELDER-LAW or text the word probate to 601-600-2662. We'd love to send you a copy.
Great. Okay, next question. More about wills. What happens to my estate if I do not have a will?
So if you don't have a will, I've got good news for you. The state of Mississippi has done one for you. And we call that the intestacy law of the state of Mississippi. Intestacy is just a fancy Latin way that we lawyers have to say that means die without a will, because we like to use our Latin, right?
Sure.
And so, if you die without a will, the state of Mississippi says, well, your assets will be divided equally between your spouse and your children.
Okay.
Equal shares. That's usually not what people want. Usually, if they have a spouse, they want everything going to the spouse. They don't want their child getting an equal share with their wife. But that's what the intestacy law does. If you want to do something different than what the intestacy law does, you have to do a will or have title to those assets owned in a manner that doesn't pass through that intestate estate.
Okay.
And so that's really the purpose of a will. Is it's your wishes, it's your will as to how you wish your property to be dispersed at the time of your death. It's a testamentary instrument of this is what I intend at my death, not before, but at my death.
Okay.
And so that's really why we have wills, and without it, again, we have a default statute. If you have no spouse, it's going to be equal share between the children. If a child's deceased, it's going to drop down by representation to that child's children. If there are no children and no grandchildren living, it's going to go equally to parents, I believe, and siblings. If a sibling is deceased, I don't remember if it passes through representation or not. It's always it comes across so infrequently that I always have to dust the statute off and see. But it goes out about 5. The statute actually goes out about 5 generations, some of which take by representation, others of which do not. And so it would depend in that circumstance as to who's alive if you die without a will, as to who ultimately winds up getting things. There's a misnomer out there of, if I die without a will, the state gets everything, and that's exceedingly, exceedingly rare. Usually, the statute, goes out multiple generations. We can, I've never been involved in one that we couldn't find somebody that actually inherited the property that we could make a distribution to through that intestate estate.
Some distant nephew that never even knew about the uncle.
It's
in the movies.
It's the Monopoly card, right?
Yeah.
Your great uncle passes, and you collect $500.
All right. If I have a personal attorney, do I need a separate attorney for probate?
So you don't. So probate can be handled by any lawyer. We in our firm specialize in elder law and estate planning. We have specialty designations for that, and it's the only type of work that we do. That being said, the practice of law in Mississippi is a general practice of law. Anyone with a license, anyone that's been given a bar license, passed the bar, and been deemed to be fit to be an attorney, can practice any type of law that they want to without any type of limitation. So there's no specialty that you have to go to. We've just chosen this specialty as being the only type of work that we do for a number of reasons. So any lawyer can handle probate if they choose to handle probates. That being said, you don't have to go back to the lawyer that did the will. If you have your own lawyer, they could be the one handling the probate for you. By the same token, if you'd prefer to use the one that did the will, you're welcome to do that as well. Or you may not like either one of them and choose someone else. You could call our firm, and we'd be happy to help as well. There's nothing that locks you into any firm, even frankly, if it's in the documents. The fiduciary, the person that's named, has the fiduciary obligation to manage that estate properly, and so they get to hire the experts that they get to rely on. They're not going to be bound by any pre-designation or any preference that's put in those documents. That being said, most people will go back to the lawyer that drafted them because that lawyer has personal knowledge about the execution of those things, has personal knowledge as to how it was drafted and what's contained in it. And so generally speaking, that's what's done, but there's no obligation to that at all. You can use any one that you choose to probate an estate. And
if their personal attorney happened to not practice probate law, they probably have a good referral for them knowing
certainly.
them.
Yeah, I mean, and there are lawyers. I mean, we get calls every day asking, do you handle car
family
wrecks,
law or
do you do divorces? We do not. But we have a network of lawyers that we refer things to, and so lawyers that don't handle that type of work, certainly would have someone that refer to that type of work too.
Okay, but your firm definitely handles probate law.
Yeah, it's what we do.
You've written a book on it.
we help people plan their estates, and then we help them administer their estates. And so this is the probate part is the estate administration piece of that. So.
Okay. All right. What happens if my husband did not have a will? Do I still have to go through probate?
So, that's a question that we get in various forms a lot, because a lot of times one spouse will die and there is no need to go through probate. Not because probate is not something that's required when a spouse dies, but because most of the time, or at least many times, the spouses own their assets jointly, what we call joint tenants with rights of survivorship. And so they've got joint checking accounts, joint savings accounts. They own their house as joint tenants' rights of survivorship. That joint part means both of them are the owners. The rights of survivorship means that if one dies, the survivor gets the entirety of it. I like to tell people the person with the last pulse wins. And so with the right of survivorship, there's no reason to go through probate. The title itself places title solely in the hands of that surviving spouse, the survivor.
Okay.
So we don't have to probate. They always do is really file a death certificate at most to tell the world this is the order people died in. That being said, on the second spouse's death, unless they've remarried or unless they've somehow retitled all their assets to be jointly owned with their children or given their assets to their kids, if they own things solely in their name, they will have to go through probate, or their estate will have to go through probate in order to ultimately determine who gets it at their death. So we on many times will avoid probate on the first spouse's death, only to have probate then go through on the second spouse's death, unless they take some action like creating a revocable living trust.
Okay. All right, Libby has another question. She says, if I own real property, is it important to seek a consultation and cost? Thanks for staying with us, Libby.
So I'm not sure I understand the question, but I'm going to try to read between the lines, I guess.
Okay.
And that is, owning real estate, you can own real estate a number of ways. You might have inherited it, you might have purchased it. At some point you've either got a deed with your name on it, or you got a will, or just heirship, or court order in someone else's probate that says you're one of, or maybe you're the sole heir of that property, and so you're the owner of that property. Once you got it, there's no real reason to consult with anybody unless you're wanting to take some action like transfer it, in which case you might need a lawyer to draft a deed transferring it to someone else. Or if there's some question as to the title, you might want to go to a real estate lawyer and get confirmation of that title to confirm, yes, I do own this entirety, or I do own this 1/8 share, or what have you. But the very fact that you inherited property, the very fact that you bought property, doesn't require some ongoing consultation with a lawyer. No. The deed and the title record determine who owns it. So unless there's a cloud on that title or something, there's nothing to do. Now, if there's some question, someone else is claiming ownership with you, there very much is a reason to go seek an attorney at that point, because you may have rights that if you sit on those rights, you're going to lose them. So if there's some question that you've got other than just, okay, I own this, do I need to see a lawyer? If there's some question about that ownership, then yeah, make sure and protect your rights. You need to go see a real estate lawyer that can confirm title, that can make sure there's no adverse possession against that, and that sort of thing.
Okay, great info. All right. What are some ways that I can avoid probate that do not cost a lot?
Okay. Well, there are a number. We've mentioned a few of them. So owning real property as joint tenants' rights to survivorship will avoid probate if there's a survivor. And that's done simply with a will. A will is generally about $150 or so. So that's relatively inexpensive. Bank account or brokerage account can be owned as joint tenants' rights to survivorship, and that costs zero. Other than a little bit of time going to the bank or going to the brokerage firm and getting that retitled with your co-owner. They'll just retitle those assets, and now you're both owners with rights to survivorship. You'll usually say on there JTROS, that's just shorthand for joint tenants rights to survivorship. Then that would avoid probate as to that asset. Some assets have beneficiary designations. So it may be a bank account with a pay on death designation that you could put on there. It may be stock with a pay on death designation, maybe a brokerage account like that. Sometimes the beneficiary is built into the contract. So some assets that you have are contractual assets like annuities. You'll name a beneficiary on the annuity. So while you're alive, you might be the annuitant, you might be the owner. At your death, the beneficiary then becomes the owner of those assets. Same thing with a retirement account, an IRA, individual retirement account, or a 401k or 403b, any of those retirement accounts, or even pensions. You can name and should name beneficiaries because those assets pass outside of the probate process, outside of your estate. They pass directly to the beneficiary of those assets. So those are some things that you can do, is especially with personal property, you can have those assets either jointly owned or with beneficiary designations on them. The real tricky one comes in with the real estate. With real property, you can't have a pay on death deed. So I can't have property that I own but pay on death to my son or pay on death to my daughter. I can have that property jointly owned, but once I make it joint, now I'm not the sole owner of that. That has adverse tax consequences. It has adverse potential creditor consequences. So that's usually not a good thing to do. It's not worth avoiding probate simply to give part ownership away to that. And that beneficiary designation is not something we currently have in our law. Some states do, but currently in Mississippi, we don't have pay on death deeds. The closest thing we have to it is something called a remainder interest, where you can retain a life estate to real property and give a remainder interest to a surviving child or parent or anyone else. And at your death, then they get what remains. But again, that has some adverse consequences, some potential adverse consequences. We generally don't recommend it because you can't undo it. In other words, if you own it, you can do whatever you want to with it. If you just own a life estate, you now don't own the entirety of it. You only own the part that is the use and enjoyment of the property while you're alive. So, while those are some ways around probate, probably the best way around probate, especially for those types of assets, is a trust. Okay. And that might be a revocable trust. It might be an irrevocable trust. But either of those are going to avoid probate because the trust lives on. If the trust owns the assets while you're alive, and then at your death, the trust continues to own the assets, there's nothing to probate. There's no question mark as to who is the owner of this. Okay.
Let's see. So, Ronald, we had a total of 35 questions submitted about probate here.
Wow.
And we are running out of time here, and we only got to, let's see, which one was that? I think you actually answered the next one about they wanted to know how she and her husband could avoid probate in other ways. So I think you just mentioned that. So that means we're on question number 12 out of 35. Okay. So we may have to do this topic on your next visit to
We might. I think the next visit we're going to do is actually veteran benefits.
Veterans.
So we're going to look at a special type of
Veterans
benefit.
Day on Monday.
It is. If I'd planned ahead, I would have done
that today.
for this one, but we'll be a month late. But we're looking at a special benefit called a special pension for aid and attendance. Okay. And it's a great benefit that a lot of people aren't aware of that will pay a significant amount of money for a veteran, about $1,800 a month. Okay. For a married couple, about as much as $2,400 a month, or even a widowed spouse of that, of a veteran, about $1,200 a month that can be used toward in-home care, assisted living, or nursing home, and it's tax-free money. People don't know about it, so I want to. Next presentation we'll take questions about that VA benefit.
VA benefit. So you heard it here. You can send your questions for that episode to our Ask the Experts page on WLBT.com. I'm going to check the page for the schedule and see when Attorney Morton is coming back. It looks like that date's going to be
probably Christmas Eve.
December 20th.
Close.
Yeah, right around Christmas. We might have a tree or something in here. We'll have some cookies. All right, so send your questions for that date. Maybe we'll try to get some of these probate ones answered that day too. Maybe you have to split it up depending on how much. Sorry we didn't get to all the questions today. Thank you for watching and for your questions. Thank you for your expert answers there
Thank you.
today.
And if you want more information, again, 601-600-2662, text the word probate, or call our office at 601 Elder Law.
All right. Thank you all for watching. Have an awesome weekend.